What controls a trust or a will? The circumstances are I was contacted by a person that his parent passed away, leaving a trust. The trust directed that certain estate property go to persons other than this prospective client. So let's give a scenario. 4 kids, 1 parent, some properties were going to the other 3 children. Ask me about that, what could be done, and whether there's cause for an action. Is there a certain type of litigation that can address that circumstance? He also advised that there was a will, cannot get or receive a copy of the will. He believes that one of his siblings has the will, or he understands that to be the case. And that sibling says, you don't need to see the will. The will isn't going to be used. That could be the case. It could be the circumstance that when the person passed away, none of their assets were in their personal name. If you have no assets in your name personally when you pass away, or even if you own it in a corporation, but if it's in your individual name. So an individual owns a corporation that owns a property, not a trust owns a corporation that owns a property. So if a person has an asset in their name, then you have to probate a will because it wouldn't have been in the trust. So if I have a property inside of the revocable living trust of Frank Bruno, well, then you never have to use my will when I pass away because you just have to administer the trust. Make sense? If I have an asset, I own a property in my own individual, and I also have a trust, you still have to go by my will because I owned that house, that property in my name at the time of my passing, and I can't sign a deed. So you need to get the permission and authority of the court for someone to be made executor, a fiduciary for my estate, to sign a deed, to make a contract, to get the house from my personal name into the names of my loved ones, or to sell it and then divide the money. So this person that called me may be in a terrible position where he was provided for in the will, then a subsequent trust left him. I have to look at all the documents, but it could very well be that the will, even though written, will never be used. I'll give you a different example. Let's say a person has $10 million in their name and they write a will. They leave everything to my son. Then they spend the $10 million during their life and they have 0 at their death. Well, it doesn't matter that the will says everything to my son because it no longer exists. The person in that example spent their $10 million. So the son that was going to receive $10 million will receive 0. And that will never be probated because there's no estate assets to probate. Same way that the trust would take over because there's no will probate. There is a will to probate, but there's no assets to distribute. If you have questions, reach out, frankbrunolaw.com.